Live from the drama-free true crime destination. No fluff, no filler, just the bites, breakdowns, and bold truth you need. This is the Midweek Bite. Ooh. And a good Thursday evening, everybody. Welcome to Bethea'S Byte Reloaded. Welcome, everybody, East Coast, West Coast, North Side, South Side, and everywhere between. I'm Ernest Bethea, the last Outlaw, and this is the Midweek Bite. And tonight, it's a full midweek docket with major developments from coast to coast, from new indictments and explosive courtroom moments to breakthroughs in long-running investigations. We're tracking the cases that move today. So, without further delay, it's showtime, folks. We are going to kick off the evening with a judge denying a new trial for convicted killer Jose Ibarra. All right, there you go. So let me give you the short version first, and then I'll get you to the article. In Georgia, a judge has denied a new trial for convicted killer Jose Ibarra, ruling the evidence against him was overwhelming and powerful, leaving his conviction fully intact. Here's what happened. A Georgia judge for a new trial for Jose Ibarra, saying that evidence presented of his guilt was overwhelming and powerful. Ibarra was convicted of multiple charges, including malice murder, felony murder, kidnapping with bodily injury, and aggravated assault with intent to rape for the death of Laken Riley. Riley was a nursing student at the University of Georgia who had been out for a run when she was attacked. Ibarra appealed his conviction, arguing in part that his attorneys had not given enough time to analyze the DNA evidence against him. But Judge H. Patrick Haggard said that Ibarra's attorney represented him capably and appeared to grasp the evidence. It appears to the court from the manner in which the trial counsel questioned the expert at trial that counsel had a sufficient knowledge and understanding of true allele DNA and effectively cross-examined the expert on the topic. Trial counsel claims her argument as to this topic was hampered because she was unable to secure and present a defense expert. But the court finds that she effectively articulated flaws with true allele in her closing argument. Judge Haggard noted in his opinion denying the motion that Ibarra's appellate counsel failed to call his trial counsel as a witness when he heard arguments on the motion for a new trial in January. Because appellate counsel elected not to call trial counsel at the motion for a new trial hearing, this court will presume counsel's actions are reasonable and a matter of trial strategy. While Ibarra's motion Judge Haggard said they had plenty of time. The first true allele DNA report was given to the defense in May of 2024. But Haggard wrote in his opinion that the defense didn't consult with an expert until October, even after receiving the raw data from the DNA testing. The defense had more than a month before the start of the murder trial. Ibarra was sentenced to life in prison without the possibility of parole. As I said at the opening, the conviction remains fully intact. Running it back now, the defense had claimed they needed more time for the DNA review. Cell phone evidence should have been excluded. The court erred by denying a continuance, and an alternative suspect theory involved Ibarra's brother was plausible. The judge, as I mentioned in the article, dismissed each point, finding no legal basis to disturb the verdict. Ibarra now has 30 days to file with the Georgia Court of Appeals. And in my personal opinion, I believe that one is going to fall flat. So, in prison he's in now, and prison is where Jose Ibarra will stay. Next up, a high school senior murdered a woman asleep in her bed in a random attack, according to prosecutors. Let me go ahead and get that set for you guys while I give you the short version before this article. In Massachusetts, prosecutors say an 18-year-old high school senior broke into a home and murdered a woman as she slept, calling it a completely random attack. All right. In fact, you know what? Let's go to his arraignment before we go any further. I'm just going to go ahead and mute myself and let everything you see here speak for itself.
Docket 3/4/2026, an arrest at Danvers. March 12, 2026, murder, home invasion.
All right, so we're pleaded not guilty once we're reading that. Counsel, are you private? And it's my understanding earlier today, Counsel, that you made a request with regards to an evaluation from the court clinic.
That's
Is that
right.
right?
That's right.
And so, ma'am, could you just identify yourself?
Certainly, Dr. Joyce Perara, designated forensic psychologist.
All right.
I do, Dr. Joyce Perara.
Good afternoon, Dr. Peralta. Did you have an opportunity to evaluate Mr. DeMayo?
I did, Your Honor.
All right.
I interviewed Mr. DeMayo for a little over an hour with counsel present, and I also spoke with family. I presented the warning of limits of confidentiality, which Mr. DeMayo understood. Mr. DeMayo is 18 years old. He presents today with depressive symptoms, including restricted affect, anhedonia, and suicidal ideation. Indication is these symptoms have existed for some time. Partial responsiveness on interview leaves open the question of possible psychotic process. He demonstrated adequate factual understanding of his charges and the court process given his lack of previous experience in criminal court. However, I have concerns about his rational understanding and the potential impact of his current functioning upon his legal decision-making. I am recommending further evaluation of both his competency to stand trial and his criminal responsibility. That evaluation, in my opinion, needs to take place in a hospital for further assessment of his mental state. Given the nature of the alleged index offenses, in my opinion, the strict security of Bridgewater State Hospital is necessary. If the court commits under 15B, the return date should be April 1st.
Thank you.
You're welcome, Your Honor.
To you report any questions for the doctor?
I have a question.
Thank you very much. How long are you seeking as far as bail is concerned?
So, Your Honor, good morning. Erin McAndrews for the Commonwealth. The Commonwealth is seeking that the defendant be held without bail.
By agreement?
Yes, reserve them.
And Your Honor, the Commonwealth does have a statement of facts for probable cause. On March 12th of 2026, a male subject, later identified as 18-year-old Anthony DeMayo, was apprehended by Lynn police after a 911 call reported observing DeMayo walking down Standish Street with a knife. While the investigation was unfolding, DeMayo informed Lynn police officers that he had killed a woman the night before in Danvers, Massachusetts. The Lynn Police Department executed a search warrant at the DeMayo residence in Lynn, where they located clothing that had stains consistent with blood. As a result of the evidence located during the search warrant and cell phone data of DeMayo's phone, the Danvers Police Department and the Massachusetts State Police conducted a well-being check at 17 Amherst Street in Danvers. Officers located 69-year-old Janet Swallow, alone, deceased in her home, suffering from wounds consistent with a homicide. Based on the investigation, DeMayo entered the residence by climbing in the window and stabbed Ms. Swallow while she was in bed. It does not appear that any items were missing from the home. Investigators believe that the defendant acted alone at that time and that this was in fact a random attack. At this time, the Commonwealth has also filed a motion to impound the criminal application with the attached memorandum and signed affidavit that I could pass up now.
Yes, please.
I have provided one to my brother as well.
All right, counsel, any objection with regards to the motion to remand?
No.
Motion's allowed without objection. Come on with anything else?
No, Your Honor.
So the defendant is going to be held without bail during the pendency of this case. I understand, counsel, you're asking that it be without prejudice at this time. In addition, pursuant to Chapter 123.15a, as far as the evaluation is concerned, the doctor has opined that that the defendant needs additional evaluation that should be done in a strict security setting, which would be done at Bridgewater. And that period should not exceed more than 20 days, which is a date of April 1st. So what I was thinking, counsel, is that we schedule it for probable cause hearing on that April 1st date, as well as a return date on the evaluation for both competency and criminal responsibility. He'll be held without bail during that period of time. Anything else from either party?
No, Your Honor.
Okay. Thank you. Court officer, could you hold him for 1 second? Sorry. Could you pull him back? I'm sorry. Mr. DeMayo, I did not give you your bail warning, which means that during the pendency of this case, you cannot pick up any new criminal charges. And if you violate any conditions that the Commonwealth could ask specifically that you be held in custody for up to 90 days. Do you understand that?
Yes, Your Honor.
All right, thank you. You're all set. You go first.
And there's that. 18-year-old Anthony DeMayo charged with murder and home invasion in the death of 69-year-old Janet Swallow was found in her Danvers home by police on last Thursday. He was taken into custody on last Thursday afternoon in Lynn, Massachusetts, after someone called 911 to report a person walking around with a knife. It was like a 6-inch blade, and he was just swinging his arm around, and then he was just started stabbing all the bushes. The 911 caller, Ashley O'Brien, told WCVB. Like he was pretending the bushes were a person. Like it was practicing. It was the most bizarre thing I've ever seen, quote unquote. Responding officers described the suspect as behaving erratically and took him to the hospital. While in custody, DeMayo allegedly told officers that he had killed a woman the night before in Danvers, Massachusetts. Prosecutors had mentioned this in court on last Friday. In court documents reviewed by the Boston Globe, DeMayo allegedly told officers that he planned on committing this act for a long time and wanted to kill someone for a long time. He further admitted to climbing into the victim's home by ripping a screen off her window before going into her bedroom and stabbing her in the neck, according to the paper. After the knife became stuck, he pulled her off the bed and onto the floor, according to those documents. At a news conference announcing the arrest, Essex County District Attorney Paul Tucker described the murder as random, saying that there was no connection between DeMayo and Swallow. Forensic psychologist Joyce Parada testified at DeMayo's arraignment that she evaluated him during an hour-long interview. She described the teenager as presenting with depressive symptoms, including depressive affect, anhedonia, and suicidal ideation. Indication is these symptoms have existed for a long time, end quote. Dr. Parada recommended DeMayo be sent to Bridgewater State Hospital, saying, quote, I have concerns about his rational understanding about the potential impact of his current functioning upon his legal decision-making, end quote. At the hospital, DeMeo will be further evaluated ahead of his next court date. DeMeo was described by investigators as a senior at Bishop Fenwick High School, a private school in Peabody, Massachusetts. And that's all. That's all I have in my own notes as well. So we just have to wait and see exactly what's going to become from this forensic mental health evaluation, because if you're going to, I mean, if you're going to go around swinging your arm with a knife in your hand, and then stabbing the bushes like you're actually stabbing a person, and then escalate that further to actually stabbing a person in the neck while she's at home asleep, something has got to be wrong upstairs, and I'm not taking that lightly. So I'll just hold off on my own personal commentary about the whole thing until I get more information. Next up, here's a case of want to, but you can't. The prosecutors want to use a teen's text about wanting to kill a baby at trial. The judge in that trial says, you can't do that. All right, hang on just a second. Let me give you a breakdown real quick. In Florida, why am I not shocked this is in Florida? In Florida, judges ruled that prosecutors can't use a teen's text joking about killing the kid, saying they're character evidence, not proof of intent in a campus newborn death case. Here's a quick what happened here. A Florida judge has ruled that prosecutors cannot introduce a set of text messages sent by defendant Brianna Moore. You'll see her on the right-hand side of your screen. Just give me 1 second to pull her face up a little bit where you can see her. Boom. There you go. That's Brianna Moore. In which she joked about killing the kid, quote unquote, as a form of birth control in her upcoming trial for the death of her newborn in a University of Tampa dorm room. The court found the following. The texts were sent when Moore was no more than 4 weeks pregnant. There's no evidence that she knew she was pregnant at the time. The messages were dark humor, not a plan. And their only effect would be to portray her as the type of person who would do this, quote unquote. Because of that, the judge ruled the texts are inadmissible character evidence, not proof of intent. The ruling leaves the door open for the state to revisit the issue only if the defense opens the door. Now, keep in mind, I have not read the article just yet. I've only showed you Brianna Moore's face, and all I can say is this. If this proves anything to the effect that Brianna Moore did harm her child in some way, then she should get the book thrown at her. Here's the breakdown from the report in Tampa, Florida. Florida prosecutors were dealt a blow when the judge ruled they will not be allowed to use a defendant's text messages against her. Brianna Moore is charged with aggravated manslaughter of a child and child neglect in the death of her newborn daughter, who was found in a trash can inside her dorm room at the University of Tampa in 2024. Moore, now 20, being denied being pregnant and told officers that the blood visible in the bathroom was from her period. Prosecutors had intended to use text messages between Moore and someone labeled in her phone as Qasim as part of their case that they say showed Moore's intent to kill her child. the conversation and text messages went as follows. Qasim. Plan A was condoms. Plan B was the pill. Plan C was to kill the kid. Quote, end quote. Brianna Moore's response, quote, Plan C is my favorite, end quote. In a new order, Judge Thomas Palermo ruled the messages inadmissible in the state's case in chief, finding them inadmissible character evidence. The messages were dated September 13, 2023, when Moore would have been at most 4 weeks pregnant. Judge Palermo found there was no indication Moore knew she was pregnant when she had the conversation, and that the messages don't detail any specific plan or intent. It does not even express that the defendant would consider this course of action if she ever became pregnant. Judge Palermo wrote in his order, quote, its only relevant purpose is to how that defendant is the sort of person who would kill a newborn child, end quote. Judge Palermo did leave open the possibility the messages could come before the jury. If Moore's defense opens the door during its case in chief, if that should happen, prosecutors will have to seek permission outside the presence of the jury prior to introducing the messages. Moore's trial was scheduled to begin on March 30th, but was postponed with no new trial date immediately available. Moore has pleaded not guilty to those charges. Yeah, like I said, if Brianna Moore is guilty of neglecting a child at 4 weeks pregnant, or what was the other charge? How deep was that murder? Aggravated manslaughter of a child and child neglect. Like, yeah, she should get the book thrown at her, but I don't think that the text message is gonna even make it through the trial unless the defense opens that door. If the defense wants to play strategy, I would suggest don't open that door. Don't open that door. All right, next up on our docket. A man is arrested in Utah after a grandmother was found murdered in Wisconsin. I told you we're going across the country, ladies and gentlemen. Utah to Wisconsin. All right, here's the short of it. In Utah, police have arrested a Wisconsin man accused of murdering his grandmother after relatives say he confessed and fled the state. That's the short version. Here's a version courtesy of Court TV's coverage in Ogden, Utah. Video from body cameras shows the moment a murder suspect was taken into custody in Utah. 36-year-old Randy Jenks is charged with first-degree intentional homicide in Washoe County, Wisconsin. Deputies say they were called to do a welfare check on the evening of March 8th. When they arrived, they found the victim dead. The victim was identified as a 75-year-old, was allegedly found lying on the floor with dried blood around her. That's according to WTAQ. Shout out to them. A relative reportedly told officers that Jenks confessed to the murder before he took off. I stabbed grandma in the living room on the floor, quote unquote. That's what Jenks is reported to have said. A relative also told police that Jenks confessed to the murder after his grandmother, quote, pushed him too far, end quote. That's according to a complaint reviewed by WLUK. Shout out to them. Jenks was arrested later that evening in Ogden, Utah. Body camera video shows Jenks calmly approaching police with his hands in the air, one holding a phone, as he complies with officers' commands. Jenks will have to be extradited from Utah to Wisconsin to face charges. As of right now, no court dates have been scheduled. Again, Randy Darius Jenks is charged in Wisconsin with first-degree intentional homicide in the killing of his grandmother, now identified as 75-year-old Patricia May Glenn. Deputies in Washoe County discovered Glenn deceased during a welfare check with dry blood visible around her body. Multiple relatives told investigators that Jenks confessed to the killing before fleeing the state. He had been living with his grandmother for more than a year. Jenks surrendered without incident when Utah officers located him, and he's now awaiting the extradition back to Wisconsin. What in the world is this world coming to? I mean, it's not just children killing their parents, it's grandchildren killing their grandparents. And they're doing everything they can to help you out. I guess we'll have to wait and find out what's going on with this particular case too. It's shocking to me. Next up, remember we covered the woman that was accused of holding her stepson captive for years? Well, that lady, if you can call her that, is facing new charges. Here's what's going on. We got in Connecticut, prosecutors have filed new and upgraded charges against a woman accused of holding her stepson for use, now including first-degree kidnapping and assault. Let's go to courttv.com. Let's see what we got here. We're in Waterbury, Connecticut. A Connecticut woman accused of holding her son captive inside her home for decades appeared in court last Thursday after prosecutors filed new charges against her. Kimberly Sullivan now faces 2 charges of first-degree kidnapping, along with charges of assault, unlawful restraint, and intentional cruelty to persons, according to records reviewed by Court TV. The charges mirror those she initially faced when she was charged last year, but were updated to reflect the new information, according to prosecutors. The new information wasn't immediately made available to the public. This is our defendant here on the right side of your screen, Kimberly Sullivan. The 32-year-old victim now has asked to be called S since his rescue in February 2025. S was rescued by firefighters after the alleged victim intentionally set a fire in the house where he told investigators he had been locked for more than 20 years. Sullivan has denied any wrongdoing. Sullivan's attorney, Ioannis Kolotis, told reporters following her brief appearance in court on Thursday, saying, "This wasn't true then, it isn't true now." When asked why S weighed only 68 pounds when he was rescued from the home, Kolotis shrugged and responded, "We'll see." Kolotis said the new charges don't change anything for his client, who maintained her innocence and is free on a $300,000 bond. Kolotis added, "As you can imagine, anytime your face is plastered all over the news and you become public enemy number 1, it does make it difficult to go out and resume a normal life." Before I go to the breakdown of all that, all I can say is, duh. I mean, you're charged with holding your stepson captive for decades. And you're thinking you're going to be able to go out and just do whatever, not people recognize you. You might as well just have that criminal defendant label written all over you, and just own that, because until this trial happens, and well, let's look at it both sides. You can either be found not guilty and you can walk away scot-free. They're still going to remember you for what you're charged with. Or you could end up being found guilty and you have to spend a great amount of time behind bars, and those very same people you're worried about not not recognizing you, they won't have to worry about that because you will never see the light of day for a while. At least. And that's the new filing counts of first degree kidnapping, which is upgraded from one count of second degree kidnapping, first degree assault, first degree unlawful restraint, cruelty to persons, and reckless endangerment. Investigators are saying the victim, now in his early 30s, told first responders he had been locked in an 8x9 room for more than 20 years, given minimal food and water, and removed from school after concerns were raised. He weighed under 70 pounds when he escaped by setting a fire inside her home. And as I've mentioned, Kimberly Sullivan remains free on $300,000 bond. Her next pretrial hearing is set for April 30th. All right, next up. If I can. Next up, a Microsoft executive's accused killer is ordered to stay in jail despite alleged gunman's new story. That's the very gunman who decided he was going to change his plea and take his chances with trial. This story, as you already know, is coming out of Jacksonville, Florida. But here's a brief synopsis. In Florida, a judge has ruled that the accused mastermind in the killing of Microsoft executive Jared Britigan will stay jailed, rejecting a news story from the admitted gunman that contradicts his earlier sworn testimony. Here's the entire breakdown. The man accused of funding a murder for hire that killed a Microsoft executive in front of his young daughter will remain behind bars until his trial this summer, according to that Florida judge. Mario Fernandez Saldana is charged with first-degree murder, conspiracy to commit murder, solicitation, and child abuse in the death of Jared Britigan, a computer executive who was gunned down in Jacksonville Beach in 2022. At the time of his death, Britigan shared custody of his two older children with his ex-wife, Shauna Gardner, who is married to Fernandez Saldana. Gardner is facing the same charges as her husband. Prosecutors say Gardner and Fernandez Saldana paid a tenant living at a property they own, Henry Tennant, to murder Britigan. Tennant initially pleaded guilty and agreed to testify against the couple, but withdrew his plea last month. He will now face his own trial and will not cooperate with prosecutors. In the wake of Tennant changing his story, Fernandez Saldana filed a motion for bond. Fernandez Saldana argued through his attorney that evidence only ties Tennant to the murder. In a written decision filed on Thursday, Judge London Kite refused to grant bond for the defendant, citing the weight of the evidence against him. While Tennant's story may have changed, Judge Kite pointed to the affidavit that says surveillance video and DNA evidence proved he was the gunman, even without his confession or cooperation. Tennant lived in a home managed by First Choice Home Rentals, LLC, which lists Gardner and Fernandez Saldana as authorized managers. Judge Kite noted that cell phone data showed Fernandez Saldana's device going to Tennant's property, several payments sent from the First Choice Home Rentals account to Tennant, and 5,400 records deleted from the defendant's phone, as giving weight to her decision. Gardner and Fernandez Saldana had initially faced a potential death sentence if they were convicted, but prosecutors withdrew their intent to seek the death penalty after Tennant changed his story. The couple is scheduled to stand trial in August, but no trial date has been set for Tennant. Okay, this is what the judge had found. Tennant's new version is inconsistent, number one. Number two, The original evidence tying Fernandez Saldana to the plot remains strong, and there is no legal basis to revisit bond or release. So, knowing all that, Fernandez Saldana will stay behind bars as he awaits trial. At least there is a bright side if you're Mario Fernandez Saldana and Shauna Gardner. The death penalty is off the table. Lucky you guys. Next up, we're going to go to Detroit, where chaos erupts during the sentencing of Jarvis Butts. There was a lot of sobbing and a lot of shouting going on in that one. Okay, looks like we may get the video for that too. Oh, I like it. Courtesy of our good friends on YouTube. Let's watch together.
And ANNETTEHARRIS.
Thank you, ma'am. And there are Kleenex there if needed. Whenever you're ready.
To the Honorable Judge Nicholas John Hathaway in the Wayne County Circuit Court. Good morning. I'd like to thank the court for giving me the opportunity to speak as I stand here before you to address the concerns that me and my family have. It has been 2 years and 2 months since I reported Ms. I am missing. I want you to know that my life will never be the same. My family's life will never be the same without Messiah. And every day that I wake up with her, I wake up feeling it's another day without her. I love her and I miss her dearly. I can't tell her that because her life was I can't tell her that because her life was taken from her. Words cannot express just how much me and my family really miss and love Desire. This has impacted my life and my family's life. There are days when I can't, when I don't want to get out of bed. I wake up feeling depressed. I don't want to talk to anybody, to anyone, just getting out of bed. To do the basic everyday things that I miss, I'm sorry. I don't want to get out of bed. I wake up feeling depressed. I don't want to talk to anyone. Just getting out of bed to do the basic everyday things that I need to get done. And this has affected my health. I am seeing more than one doctor about my health, including seeing a therapist. I don't feel safe in my home. My address and my phone number has been put on social media. People have been driving by, taking pictures of my home. I have been threatened. My family have been threatened. Pictures taken of me and my family following me in my car. Pictures posted. Setting up GoFundMe raises in the Zion's name without my permission. And this has also affected me financially. And my people doing, other people doing podcast shows, emailing me. I don't know. I'm sorry.
Take your time.
Shut up.
There is a courtroom, 206 down the hallway. You can observe it.
That I don't know coming to my home. I just
Let's step out. Too late. Let's go. Let's go, man. In the red and in the black. Let's go. Let's go.
Please remain quiet.
Quiet the court!
I'm sorry.
Right, an additional reminder, if you're going to have difficulty controlling yourself, now would be a good time to leave.
Sir, I used to just.
I'm sorry, were you through now?
No, Judge, I'm going to finish reading the written statement for you.
Very good. Turn to your seat now. Mr. Makepeace, you can let her get situated. And then you can proceed.
Yes, Judge. Thank you.
I see I didn't mute, but I apologize for the constant buffering in the video. But I can go on to give you the rundown in the entire from the entire article. A sentencing hearing was briefly delayed on last Thursday when bailiffs were called on to escort multiple people out of the courtroom. Screams of expletives and "shut up" could be heard during the first victim impact statement presented on behalf of Naziah Harris at Jared Butt's sentencing. Butts pleaded guilty to second-degree murder in Harris's death, as well as 4 counts of second-degree criminal sexual conduct and 1 count of third-degree criminal sexual conduct in separate cases. Naziah was just 13 when prosecutors say Butts impregnated her and then killed her and the unborn child. The prosecutors said when they initially charged Butts that Butts knew she was pregnant and he knew he was looking for ways to abort the baby. Naziah was last seen getting off the school bus on January 9th, 2024. To this date, her body has never been found. It's been 2 years and 2 months since I reported Naziah missing, her grandmother Annette Harris testified Thursday. I don't feel safe in my home. I have been threatened. My family has been threatened. When Harris dissolved into tears on the stand, shouting was heard in the courtroom. Judge Nicholas Hathaway ordered 2 women to be removed from the courtroom. Shouting could later be heard from the hallway. Victims of Butts' sexual abuse spoke at the hearing. You were someone I called dad until you did what you did, one said. You did very hurtful things to me. I live with the trouble you caused me. I no longer look at you as a father figure, no longer as a hero, but as a monster. Butts was sentenced in accordance with a plea agreement he reached with prosecutors, which meant he will serve between 35 and 60 years for Naziah's murder and 10 to 15 years for each of the other charges. Justice will never be served, Naziah's aunt, Marquetta Harris, said to the court. You're still able to live. You're still able to get health care. You're still able to breathe without any remorse. Butts' sister, Tawana Butts, also spoke at the sentencing. She said, I had no plans to come here today. I'm here for Naziah and my nieces and the other victims that my brother harmed. Addressing her brother, she said, you made your bed. You've got to lay in it. Stand in it. Do whatever you have to do. Judge Hathaway ordered Butts' sentence to be served concurrently, and he will be registered as a sex offender when he's released. Yep. Here's all that happened. As you've seen through the video, buffering it all. The sentencing hearing erupted into chaos as Jarvis Butts was being sentenced for the murder of 13-year-old Naziah, excuse me. As victim impact statements began, Naziah's grandmother broke down sobbing. Someone in the gallery could be heard shouting, "Shut up," at her, triggering an immediate confrontation. Judge Nicholas Hathaway ordered multiple people removed from the courtroom, but the shouting continued from the hallway even after the bailiffs cleared the space. Victims of Butts' sexual abuse also addressed him directly, calling him a monster. And his own sister, as I've mentioned, said, you made your bed, you got to lay in it. Jarvis Butts received 30 to 60 years for murder, 10 to 15 years for each sexual assault count, all sentences to be ran concurrently. And the moment he's released, he will be registered as a sex offender, which is mandatory. And once again, Naziah's body has still never been found. As much as, and on the one side, I still say it's justice served to a degree, but on the other side of that, I really can't say the same thing because Naziah's family is still doing a life sentence without her. Next up, a former paramedic indicted for his wife's alleged murder with eye drops. This one seems like I've seen this or heard this somewhere before. Let's get a look. All right, we're in Gastonia, North Carolina. A former paramedic has been indicted for allegedly murdering his wife with eye drops. Prosecutors say toxicology revealed a rare poisoning involving tetrahydrolazine, which is an active ingredient found in certain over-the-counter eye drops. Let's dig in. A former paramedic has been indicted on murder and fraud charges in the death of his wife, who investigators say was killed with eye drops. 41-year-old Joshua Hunsucker was indicted by a grand jury in Gaston County, North Carolina. That's according to court records filed last week. The indictment filed on March 11th, 1 week ago today, accuses Hunsucker of first-degree murder, insurance fraud, and obtaining property under false pretense in the death of his wife, Stacy Robinson Hunsucker. While Joshua Hunsucker told friends and family that his wife died of a heart attack, investigators determined that she had been poisoned with tetrahydrolazine, a medication frequently found in over-the-counter eye drops. Stacy Robinson Hunsucker died on September 30th, 2018, but charges weren't filed against the defendant for more than a year. Joshua Hunsucker is facing charges of witness intimidation in a separate case in which he is accused of staging his own kidnapping and assault in an alleged attempt to frame his in-laws. Police found no evidence of a legitimate attack, but rather additionally charged Joshua Hunsucker with stalking and harassing his in-laws. Prosecutors say the defendant concocted the alleged scheme to distract attention from himself before his arrest. In 2024, Joshua Hunsucker was accused of trying to poison his own 11-year-old child, who was brought to the hospital with very low blood pressure, low heart rate, extreme exhaustion, and constricted blood vessels. The child's blood was found to contain tetrahydrolazine along with, okay, bear with me, I'm trying to pronounce this name because a lot of this stuff is hard to pronounce. Desmethylvenlafaxine. Easy for me to say, right? The second drug, not approved for use in children, is used in the treatment of depression. Investigators say they found the drug in Joshua Hunsucker's truck. Court records indicate that Joshua Hunsucker is due to return to court for an arraignment in April. Wow. This guy's got a penchant for using things that that's supposed to help you to hurt you in some form or fashion. Prosecutors allege that Joshua Hunsucker administered the substance over time. The poison caused a fatal cardiac event. His medical training gave him knowledge of the drug's dangers, and the death was initially treated as medical until toxicology flagged abnormalities. The indictment marks the first formal step toward trial, and the defendant has not yet entered a plea. Well, we'll find out what that'll sound like in April as this case rolls on. Next up, a DA says that the remains believed to be a Massachusetts woman were found under the garage floor. We're going to Lowell, Massachusetts for this next case. In Massachusetts, investigators have found human remains beneath the garage floor believed to be a missing woman, which marks a major shift from disappearance to likely homicide. Here's the article. A Massachusetts man is charged with murder after investigators say they found a body buried in a shallow grave beneath his garage floor. 40-year-old Sean Sullivan is charged with murder, assault, and battery with a dangerous weapon, and improper disposal of human remains, according to Middlesex District Attorney Marion Ryan. Ryan said detectives in New Hampshire got a call on March 10th, tipping them off that Sean Sullivan told a friend that he killed a woman named Jill at his home in 2025. Sullivan allegedly claimed to have shot the victim before burying her beneath the floor of the garage in Tingsboro, Massachusetts home. Jill Kloppenberg was reported missing in neighboring Tewksbury, Massachusetts in February 2025 by friends who hadn't seen her since August of 2024. The last people who reported seeing Kloppenberg saw her leaving her Lowell home on January 2nd, 2025, according to the FBI. Ryan said that when detectives arrived at Sullivan's Tingsboro home, they observed a large patched area, approximately 5 feet by 3 feet in the garage. Ground penetrating radar confirmed that something had been buried. Working with the medical examiner's office, investigators cut through the floor and recovered a plastic body containing human remains. While the medical examiner was able to confirm that the remains are human, they have not been identified yet. Sullivan is charged with the murder of Jane Doe as investigators work to confirm that the remains belong to Kloppenberg. Ryan said on last Monday that Kloppenberg and Sullivan were friends at the time of her disappearance. Sullivan is expected to make his first appearance on yesterday. Let's take a look at let me get a look here of how I have this here. Yeah. Investigators searched a home in Massachusetts, uncovered human remains buried beneath a concrete slab in the garage. The district attorney says the remains are believed to be those of a missing local woman connected to the property. The key details that the remains were found under a poured concrete floor, indicating deliberate concealment. The discovery was made during a targeted search tied to the woman's disappearance. Formal identification is pending, but the DA says the circumstances strongly aligned with the missing person case. No charges have been announced yet, but investigators are treating the discovery as a major development. This is a moment where a missing person case shifts into a likely homicide investigation. And when we get to that point, we can say, okay, this is what this man is charged with, if anyone. We're gonna go to Ohio for the next story on our docket, where an Amish mom is sentenced to a secure mental hospital for her son's murder. If we have the video, and I hope we don't have any buffering, we'll check that out before we go onward. And it looks like we may have video. So here's what I do. I'm gonna go ahead and mute now and then get set up. Oh boy. All right. I'm gonna mute and pray that this video, courtesy of YouTube, will not buffer as we watch the sentencing of Ruth Miller.
Thank you. Ruth, I have reviewed the exhibits that are here.
Specified or
lengthy process, quote, lengthy process. My
The intention of using that word was to indicate that this is not something that will be done in several days, several weeks, or not likely.
Okay, so that plan just went down the tube. So I'm going to go ahead and get to the article and what actually happened in just a matter of minutes. We are in New Philadelphia, Ohio. An Amish mother found not guilty of murdering her young son by reason of insanity will head to a secure mental hospital just as soon as a bed is available. Ruth Miller was found not guilty by reason of insanity on charges that she murdered her 4-year-old son and then tried to hurt her 3 teenage children. Judge Michael Ernest, who presided over the brief bench trial last week, heard testimony from several experts on Friday before issuing an order for Miller to be sent to Heartland Behavioral Health, a facility in Massillon, Ohio. The prosecution and defense each called two experts to testify at Friday's hearing, but each expert recommended the same placement for Miller. The experts, however, did not agree on the appropriate diagnosis, with some believing she suffers from bipolar disorder, others believe she suffers from schizophrenia. The overwhelming evidence, is that she does have a mental illness, forensic psychologist Dr. Daniel Hurinko said at the hearing. Miller has been receiving medications while behind bars at the jail, but has not been receiving any group or individualized therapy or services. While her symptoms are now manageable, the doctor said, Miller still appears to have a limited understanding of her mental illness and needs further education as part of her treatment. I would be concerned with limited insight. Time away from a secure setting would put her in a position to make regrettable decisions about medications, Hurinko said, which would then set a stage for a return of symptoms and the unpredictable, if not dangerous, behaviors associated with uncontrolled symptoms of mental illness. Heartland Behavioral Health is a secure facility, meaning individuals are not free to come and go. That security was part of why the experts who testified believed it would be a good fit for Miller. Judge Ernest ordered Miller to be sent to Heartland Behavioral Health, but that move won't happen immediately. There is a waiting list for beds at the facility, and the judge was unsure how quickly they could accommodate Miller. Until there is a space at the hospital, she will remain at the jail. Once in the hospital, they will be charged with determining her course of care. Miller will return to court for evaluation to determine whether she can be released in the future. The first status check will be in 6 months and then every 2 years following that. So to recap all that, the judge ruled that Miller suffers from severe mental illness, requires long-term inpatient treatment, and poses a risk to herself and others without secure supervision. Again, she's been sent to Heartland Behavioral Healthcare, a secure psychiatric hospital. But since there's a waiting list, Miller will remain at the Tuscarawas County Jail until a bed becomes available. Her first review will occur in 6 months, with additional reviews every 2 years after that. This is an indefinite commitment, not a prison sentence. Unlike this next case that we have coming up, a master manipulator is sentenced to prison for her boyfriend's brutal murder. Okay, this one I'm sure that we're gonna get we're gonna get the video for this. I'll see how far I can take this to the sentencing, but we are gonna get that. We are gonna get that in its entirety, and there will be no buffering. That's for sure. All right. So once again, I'm gonna try to mute myself out, and we're gonna watch this sentencing in its entirety.
Court also imposes consecutive sentences pursuant to 29.14C4C, finding that consecutive sentence service is necessary to protect the public from future crime or to punish the defendant, that the consecutive sentences are not disproportionate to the seriousness of the defendant's conduct, the danger defendant poses to the public, and that defendant's history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public from future crime by the defendant. Ms. Vaden, did Mr. McQueen help dispose of that body? Why did you send that text message? I'm sorry?
Due to what I was going through, he wasn't answering the phone, and it was kind of supposed to be like a message basically saying, are you okay? Like basically like call me, make sure you're okay, because I don't want you to be missing like next. It was kind of supposed to be like a, you know what I'm going through, please don't, like put me in a situation where it was just kind of like
The text is, you are going to be missing next.
yes, but like I said, it was a message. We were texting, and it was like a message, basically me checking on his whereabouts to make sure that he's
For his welfare. Okay, understood. All right, I'll take that then, as you say. I have reviewed counsel's sentencing memorandum as well. As to the involuntary manslaughter, felony to the first degree, the court will sentence you to a period of 11 years. That is the maximum sentence on that count. This will be the qualifying offense. As such, per Reagan-Tokes, there's a 5.5-year additional time that is possible pursuant to the language that I've already read to you. On this count alone, you are to serve a minimum prison term of 11 years with an indefinite prison term of 5.5 years. On this count alone, then, that would be for a maximum prison term of 16.5 years. As to count number 3, this is the felonious assault felony of the second degree. The court imposes a prison term of 8 years, which will be run consecutively. As to the gross use of felony of the 5th degree, where you employed the use of other people. With such careful intention to have them packaged up, and the knowledge over a 7-month period to the harm caused to the family, the court will sentence you to 7 months. All of that period of time will also be consecutive pursuant to the court's findings. Your sentence is 19 years and 7 months. You are to serve a minimum prison term of 19 years and 7 months with an indefinite prison term of 5.5 years. For the maximum prison term, then, I believe 25.2 years, or 25, just say 25 years, 2 months. The court will ensure that the math is appropriate. Mr. Carson?
Yes, Judge. We agree with that calculation. We just wanted to make sure there was a PRC advisement in how
Yeah.
done.
Have not done that yet.
Thank you.
On the felony of the first degree involuntary manslaughter, there's a mandatory minimum of 2 years up to a maximum of 5 years of post-release control supervision. On the felony of the second degree, it's a minimum of 18 months up to a maximum of 3 years of adult parole supervision. On the felony of the fifth degree gross abuse of a corpse, the adult parole authority has the ability to supervise you for a period of up to 2 years. It's at their discretion, or in other words, their choice. And if you violate any post-release control rule or condition, you may be subjected to a more restrictive rule or condition, a longer duration under supervision, to be sent back to prison, even though you have done all the time to which you have been sentenced. You could get up to 9 months in prison for each rule violation. The total, however, for all rule violations cannot be any more than 1/2 of the prison sentence that you receive, unless the rule violations were the commission of a new felony, in which case you could receive a prison term of the greater of 1 year, or the time remaining on post-release control, in addition to any time that you receive for the new felony. The post-release control prison term must be served consecutively, which means one after the other, to any prison that you receive for the new felony. The court will take back that Reagan-Tokes advisement form from you after the proceedings here. And there is credit for time served in this matter, which the court has calculated. 234 days, which the court will put in the journal entries, so we can have a clear record of that. Ms. Robertson, as to your motion, as to the defendant, yes. All right. The court will waive court costs and fees, finding the defendant to be indigent, and will not assess those. Mr. Strang or Mr. Mr. Strang or Mr. McNair, any further issues from the state?
No, Your Honor. Thank you.
Right. Ms. Robertson?
No, Your Honor. Thank you.
All right, thank you. All right, thank you, everyone. Thank you all for being here. I would expect deputies who want to have to be able to leave first.
Just in case you're all trying to figure out what is she being sentenced to, don't worry, I got your back. A woman prosecutors called a master manipulator has been sentenced to prison for the brutal of her boyfriend. A case the judge showed a chilling pattern of control and cruelty. A woman described by prosecutors as a master manipulator has been sentenced to prison, which was a killing marked by deception, control, and escalating violence. During sentencing, the court heard how she exerted psychological dominance over the victim, isolated him from support, and ultimately carried out a brutal, intentional attack that prosecutors argued was the culmination of a long pattern of manipulation. The judge imposed a lengthy prison term, emphasizing the cruelty of the crime and the defendant's lack of remorse. How long? Let's see if we can add this up. Let's see. Van was initially charged with murder but changed her plea as part of an agreement with prosecutors. Judge Bell sentenced her in line with the agreement, sending her to prison for a minimum of 19 years, 7 months, and a maximum of 25 years, 2 months. So, it's almost between 20 and 25 years. Youch. All I know is within that time, this young lady is going to be there. She's got a lot to think about, a lot to worry about in that time frame. But for now, what can I say? It's justice served. All right. Now, from one ending on a plea deal to one starting off with an indictment. Former cheerleader Laken Snelling is indicted for manslaughter in the death of an infant. We are now going to Lexington, Kentucky. Here's the brief. In Kentucky, former cheerleader Laken Snelling has been indicted for first-degree manslaughter in the death of her newborn. Prosecutors say the baby was born alive and then later found hidden in a closet. Here's the entire article. Former college cheerleader indicted on a new charge of manslaughter in the death of her newborn infant, which was found wrapped in trash bags in her closet. 22-year-old Laken Snelling was indicted on charges of first-degree manslaughter, abuse of a corpse, tampering with physical evidence, and concealing the birth of an infant. An arrest warrant was issued for Snelling's arrest after the March 10th incident was handed down. Snelling had been living with her parents in Tennessee while out on bond. The indictment, reviewed by Court TV, accuses Snelling of causing the death of the infant under circumstances which did not constitute murder because she acted under the influence of extreme emotional disturbance or through circumstances not otherwise constituting the offense of murder. She had intentionally abused the infant and thereby caused death. Investigators say on August 27, 2025, Snelling's roommates heard loud noises for approximately an hour. Noises so loud, they said, that they knocked a picture off a wall. Snelling told her roommates that she passed out from not eating and would be seen by a doctor. The roommates went into Snelling's room after she left, looking for the source of the noises, and found a blood-soaked towel on the floor and a plastic bag containing evidence of childbirth. They looked in Miss Snelling's closet and located the deceased newborn placed in bags. When Snelling spoke to police, she allegedly admitted to giving birth to the child, which said she fell to the floor of her bedroom, describing what happened to officers. She suggested the infant was breathing or alive. Snelling said she was awake for approximately 30 minutes after giving birth, before falling on top of the baby. When she woke up, she observed the baby turning blue and purple. Believing the child to be dead, Snelling allegedly told investigators she wrapped the baby up like a burrito and laid next to it on the floor because it gave her little comfort in the moment. Snelling's arraignment is scheduled for April 10th. Snelling was a member of the cheer stunt team at the University of Kentucky at the time of the incident. We've seen I've seen a case just like this. In fact, I've covered a case like this before. In fact, now that I think about it, we've actually done an edition of Throwback under the old format, but we did a throwback of her entire trial. But anyway, here's what happened. Kentucky grand jury has indicted 22-year-old former cheerleader Laken Snelling on multiple charges connected to the death of her newborn infant. The indictment includes first-degree manslaughter, abuse of a corpse, tampering with physical evidence, and concealing the birth of an infant. Prosecutors allege Snelling gave birth alone in her apartment. The baby was born alive, and the infant died of asphyxia. Investigators say she then placed the newborn's body in a trash bag in her closet and attempted to clean the scene. Snelling is currently out on $10,000 bond and on house arrest at her parents' home. An arraignment is scheduled for April 10. Now, she is out because she had been living with her parents in Tennessee while out on bond. So she's walking around free. She is walking around free until trial, and then we'll see what happens then. All right, next up, and I may have a few updates on this next story too. Former officer Kelsey Fitzsimmons wins additional freedom ahead of her assault trial. We're in Massachusetts, where former officer Kelsey Fitzsimmons has been granted additional freedom ahead of her assault trial, allowing her to move into her own home, but still bound by strict monitoring and testing conditions. Well, I can't wait to break this one down. A former police officer accused of threatening a colleague with a gun won additional freedom at a hearing ahead of her assault trial. We're in Lawrence, Massachusetts with this one. Kelsey Fitzsimmons is charged with assault after prosecutors say she pointed a gun at an officer with the North Andover Police Department. Fitzsimmons, who had been an officer of the same department, was being served with a restraining order by her colleagues at her home at the time of the incident on June 30th. Fitzsimmons has maintained through her attorney that her only intention was to hurt herself in the moment. Fitzsimmons was held in jail for more than 100 days before she was released under a series of conditions, which included random alcohol testing and a requirement that she live with her parents. On last Thursday, Fitzsimmons was in court with her attorneys to iron out final issues ahead of her jury trial, scheduled to begin next week on March 23rd. During the hearing, Fitzsimmons' attorney Tim Bradle, asked the judge to consider a late motion to consider the conditions of the defendant's bond. Prosecutor James Gubatos opposed any change to the conditions, arguing there had been no change to her circumstances and the restraints were necessary for the safety of the defendant and the community. If it's not broke, let's not fix it, Gubatos said. Bradle exchanged to Judge Jeffrey Karp that Fitzsimmons wanted the change to secure her own housing before a scheduled appearance in family court. Because of the language in a previous ruling, Fitzsimmons has not been allowed to have any direct or indirect contact with her young child, who was 4 months old at the time of her arrest. Deferring to the family and probate court on how best to deal with any potential contact between Fitzsimmons and the child, Judge Karp found no reason why Fitzsimmons should have to live in the custody of her mother and stepfather. She will be allowed to move into her own address subject to approval from the probation office. Fitzsimmons will also be subject to surprise visits and inspections. So here's the long and short of it. A Massachusetts judge granted former North Andover police officer Kelsey Fitzsimmons additional freedom ahead of her upcoming assault with a dangerous weapon trial. The ruling allows her to move out of her parents' home, live independently in her own residence. The judge said enough time has passed since the 2025 incident to justify loosening her bail restrictions. However, the court kept all the core safety conditions in place, which include GPS monitoring, random alcohol testing, no weapons, and surprise probation checks. The judge also denied a defense request for disciplinary records from her fiance's employer, ruling that they were not relevant to the criminal case. And again, that trial is scheduled for March 23rd. Ladies and gentlemen, if we got next week when opening statements begin, and Bethea'S Byte Reloaded will be covering that. So that is going to wrap it up for tonight's edition of the Midweek Bite. I thank you all so very much for joining me here. I could not do this without you. You guys are the heart and soul that Byte Reloaded. Well, reloaded. Oh my goodness. Let me go ahead and hit these captions real quick because I want to get all this out the way. And tomorrow afternoon, I will bring you back with more true crime coverage on the main event. So I want you all prepared for that because it'll be around 12 noon ish, maybe a little bit later than that. And I'll figure everything out, and when I come back, you'll be here with me. All right. So now, let's go ahead and get this all wrapped up for you. You can always hit me up on social media, on Facebook at Bethea'S Byte Reloaded, X at EKB316, YouTube at Bethea'S Byte Reloaded, Instagram at EKB316. Now note the difference between X and Instagram. X is all caps, Instagram is lowercase. On TikTok at King of Hearts 316 2021, and email at King of Hearts 316 _09 at outlook.com. I want to thank you all as always for taking your time to join me. If you liked everything you saw, please be sure to like, share, subscribe, comment. Let me know what you think. I would love to hear from you. This is the free way to support the channel. If you like to financially contribute, I would appreciate that as well. Well, you can drop me a little something at PayPal. PayPal me /EKB316 or Cash App $EKB316. Nothing obligated, always appreciated. Ladies and gentlemen, as always, remember where you are here. This is the home of true crime news without the drama, where your opinions matter, lively debates are encouraged, your voice is heard, and as always, above all else, justice is served. And we do this all one way. We do it one way. No gimmicks, no drama, and absolutely no BS. Ladies and gentlemen, thank you all so much. I'll do this again tomorrow afternoon or tomorrow evening in the main event. Until then, I'm Ernest Bethea, the last outlaw. This is Bethea'S Byte Reloaded. And I will see you again next time. Let me try this ending. Let me end this line one more time. This is Bethea'S Byte. And it's reloaded. See you tomorrow. Thank you so much for joining me here at the drama-free true crime destination. Please be sure to follow Bethea'S Byte Reloaded all over social media and support the channel through PayPal and Cash App. You can get your true crime news right here with no gimmicks, no drama, and no BS. This is Bethea'S Byte, and it's reloaded.